act on the issue of time, we protest. We shall require sufficient time. This sufficient time is not forever. This sufficient time, at least for purposes of the three presenting the one other application, is 1 hour. It is a list that people deserve in an application of this nature. Secondary issue, my lord, is the issues of consolidation. Those issues of consolidation are as different as UDA can be from Jubilee. And the issue is, for purposes of the difference, the application under Article 165, and we did not hear you talk about the inclusion, because we've had to include. There are earlier complaints in the morning.
I'm sorry to say this.
I have.
Yes, I want to interject. If my learned friend is appealing against your order, then there is the right point. My lord and my lady teacher.
There is no, I'm responding to what has happened. Let us be fair to each other. And my lord, what I'm saying is this, that for purposes of those applications, the application under Article 165, because in the morning when we raised the issue orally, the questions that was raised, you are raising issues against the Deputy Chief Justice, who is not a party. She is a party now, and we have served her. We took the application on the issues of the constitutional violations regarding the empanelment of this bench. We shall need the court's directions on that issue. And we've gone through the authorities within the short period that we were here. So we are standing on solid grounds. We just need sufficient time to do our business. Issue number 2, my lord, if that applications were to succeed, then it would effectively mean, as my learned colleague, Mr. Mboya, had indicated, that then the issue of recusal of your lordships becomes academic. But if your lordships were to hold that all these serious injustices that the petitioners allege were committed by the Deputy Chief Justice King, then we shall now address you, the issues that concerns you. And I need to add, on the issues of authorities, because now we've been told instructions. Well, when we came here, we thought that while we were proceeding and actions, prepare the team in the office, let them prepare authorities to argue on the issue of recusal. When you were given 1 hour, we told them, oh, stop on the issues of recusal, now we are dealing with another thing. So, my lord, we cannot be able to argue, if it is today, we cannot be able to argue, as expected by our client, on the question of recusal. And there is no similarity of issues. Therefore, my lord, I urge you that let us adopt fair procedure. This fair procedure has there a
specific application for recusal?
There are 2 applications.
Where are they?
At least I know, Gachagua will mention one. Yeah. We are actually bringing them even, one of them in number 015 is an application dated, I believe, yesterday, 21st of October. There is another one.
Okay, this these are the directions we are making. We'll deal with the application before us. The application for empanelment of this bench
Can I have the question of next year?
And perhaps, my lord, before you give the directions, with my last friend, Immortal, she's informing me that she was not aware of the elections in the morning, that applications be filed and we come back before you, and now her petition has been integrated in the consolidated petition, that is petition number E013. Therefore, she's not been able to file an application either for refusal or for challenging the panel. So just requesting if she can be served with those applications and the responses, and she be given time, 1 hour just like the others, to file her civil application if she sees. Because now she's participating in the proceedings.
Council, listen to this and listen to this very carefully. All of us acknowledge the momentous import of the proceedings before us. And all of us are enjoined by the rules of natural justice to do what is right. This bench is not going to be taken round in circles. We will not be taken round in circles. We are here to do justice for the petitioners, justice for the respondents. And anything which is intended to delay these proceedings will not be acceptable because both parties have come to this court under certificate of urgency. Let us be very careful how we argue our matters. We want everybody before us to get justice. That justice will not be possible if every advocate who stands up wants to take the cause in cycle. We will not allow that. I'm making final directions on this matter. The matter which we are dealing with is an application dated 22nd of October 2024 by Jindo Matiba and Company Advocates. It seeks orders under Rule 3 of the Constitution. We are dealing with the issue of empanelment. And then after that, we'll look at ruling for the way forward. So let us proceed. Let us be courteous to each other. Let us be courteous to the parties before us. Parties before us are very okay, but let's not be a theater by advocates to derail the process. I beg you. On the issue of time allocation, Judge Mureba will give the final issue directions on time.
This is how we proceed. The applicants will have 20 minutes to argue their application. Any party in support of that application will have 5 minutes to support that application. And the respondents will have 7 minutes each to respond to the application, as well as any other party which will want to respond to the application.
We are aware that there could be parties who, for the good reasons given, may not have filed anything. But we also appraise ourselves for the fact that the issue before the court is an issue of law. Therefore, we'll give you time to make submissions on the issue.
May I please, the client, I and my colleagues represent the deputy president, is the subject of the removal of the subject of his pleas to this court. Him not. The application for the constitutional bench is made in E015. My friend, so that effectively, the subject matter of the removal is being given only 5 minutes. I plead with you, give us 10 minutes.
How long do you need?
10 minutes. Out of 6.
You have 10 minutes. You have 10 minutes.
Yes, yes.
I feel the instructions.
Dr. Kamuna, please, we're not audible.
Oh, I'm sorry, I speak now.
Yes, speak.
I received the instructions yesterday from Victoria here that I come and make an application that Victoria here would like to be joined this meeting. We all know Victoria here. We can't pretend that we don't know and we know the role Victoria here has played in advancing the jurisprudence of the Christianity and the rule of law in this country. So I urge you respectfully that you place my name on record. Secondly, I would like also to place my name on record in my own right as an elder at the bar and one who has seen for a number of things which I may not be able to say if I'm representing the position.
That is okay. We have done that.
Thank you very much. May I then comment on one small thing? My lords, the country is not crisis. There's a constitutional crisis. There is a national crisis. And our coming to this court is like commencing or opening an opportunity for healing in the country. And if I may say so, with tremendous respect, this is not a matter where you should be allocating some 5 minutes, 10 minutes, 20 minutes. No, that is not suitable. Let these lawyers talk. They are part of the healing process to the 15 million of Kenyans. A number of them are glued now to radios and TVs, trying to hear what is being said in this court. And for this honorable court to come and say that my ever friend, Mr. Mwite, will only have 10 minutes, will have no 5 minutes.
Mr. Mwite asked for 10 minutes and we allowed him to have 10 minutes.
He said so because he was under coercion.
What? I think Dr. Kamuna.
I have taken the trouble to read this constitution of Kenya. I have taken the trouble to read the constitutions of other countries. In fact, the way things stand at the moment, the constitution law is evolving in such a manner that it's no longer confined only to Kenya. We can have a concept of international constitutional law. And if you read that law, including the American law, which I've taken the trouble to read, and which I've had access to it for many years.
Dr. Kamuna, we made proposals and we gave directions. Apparently, you are not satisfied. What is your version? What would you want us? You want to give everybody how much time?
My Lord, forget about the concept of time. Forget, where are we heading for? What are we heading for?
So, yeah.
Yeah, we want the country to wake up and to revive and to give the life to the country. The country is Kenya, if you don't know what I'm talking about. Your Honor, let the lawyers say what they want to say. This is part of the healing process of the whole country.
Dr. Kamuna, I ask you.
Yes.
We have given directions on time allocation.
Your hands are not tied with respect.
Okay, tell us, just tell us, in your view, how much time do you want us to allocate parties?
What I'm saying to the we talk about time in civil matters and so. But we are dealing here with the issue of impeachment. Issue of impeachment of the deputy president. It's not a small matter at all. It's a matter that is touching the whole nation. It has paralyzed the nation.
We have heard you, Dr. Kamino.
Let Paul Ruto be given as much time as he wants. Let the professor be given as much time as he wants. Let the Honorable Attorney General be given as much time as he wants. That is the healing process. And from this court, we shall all march forward with confidence. If I may quote Mutaja Makinata, before and buried the matako on you. Let us talk about corporate time. Where are we going?
My Lord,
where are we going with
please, Dr. Kamino.
With respect, will you sit down? Kamino is talking. Will you sit down? I am talking.
Under the rules of this court, senior counsel has preference, speaks first before any other person except the Attorney General. So if you would please sit down. I, as senior counsel.
I will not sit down. We're not practicing law. You're still doing breastfeeding.
That is also. So, my Lord,
my Lord, what
Dr. Kamino, finish what you're saying.
What I'm saying to you, my Lord, we need a healing process, and this court is going to provide that healing process. Let the lawyers say what they want to say. What are we hurrying for? Let us not have some people calling themselves professor or senior counsel, titles that don't mean anything at all when it comes to use.
I think they mean something, Dr. Kamino. They do mean something.
Something means something when it is you and you approve it. Yeah. My Lord, all that I'm saying to you, let people talk. Let people address you. Where are we going?
People will talk.
When the country is burning.
Dr. Kamino, you have made your point.
Yes, thank you very much.
You have made your point.
I have made the point.
Professor.
We have a Deputy Chief Justice who has been removed irregularly. Let us be given time to be able to address it.
My Lord, I think those of us who are representing substantive respondents, we all agree that you have given orders that we will comply with, including my learned senior PK Moite, who I believe you have added some more time and he's happy with that. Maybe it would help if we informed Dr. Kamino that it is not the whole matter that is being heard in 10 minutes. It's a very small slice of an application on impoundment. That's all I wanted to clarify.
So, Dr. Kamino, I've heard what you said. We'll stick to the time allocations, but in the event that one party needs more time, they will tell us.
When we come to substantive matters, let people.
I agree with you. I agree with you.
Yeah. Where are we heading to?
Thank you.
Yes.
In view of that time allocation, and I thank senior counsel, the senior most going by the Kenya law reports before you. May I beseech your lordship,
my name,
Dr. Kamino. My Lord, even the report of the East Africa Law confirms that. My Lord, the point I need to make, and I beseech you, because of the serious time that we had to prepare this application, I could only prepare for certain aspects of this application. My colleagues, Professor Ogada, and my colleagues, Ndegwa and Jiro, within the 20 minutes that you have allocated, I will say my piece. It is insufficient, but I'll try. Please give Ms. Professor Ogada and Mr. Ndegwa and Jiro 10 minutes each, and at the end, when we hear what the respondents are saying, you kindly give me a hint, indicate 20 minutes to do a review. That will enable us to be able to proceed without anybody feeling we want to be here forever. We don't actually want to be here forever. We want to deal with the business of the day. So that does not change any time allocations by more than 30 minutes. So I urge you a lot.
So who's starting?
I'm starting. Okay. Yes. So that I do 20 or gather 10, 20, because he has to deal with some authorities. I didn't get enough time. And he's under 10. Then I'll do the rejoinder. But not the application that is before you is dated today. It is supported by the affidavit sworn by. It is supported by the affidavit sworn by Honorable David Munyi Madenge. And for the record, all lawyers from Matiba, Ogada, Degwa, and myself, the record indicates we act for everybody without drawing any distinctions, because I believe there will be no time for that. So we act for all the respondents, for the petitioners, for purposes of E015. My Lord, before going on to argue this application, there is a small point that I wish to make regarding the issue of why are we having a situation where to everybody watching we seem to be following an unusual path. My Lord, there is one substantive issue of procedure that we need to point out. The petitioners are before you on account principally of the violations of the Bill of Rights. The petitioners are also here on account of the relevant provisions of impeachment. The petitioners are before you, my lords, on account of the fact that the business that the framers of the Constitution ordered, one, for appointment of a nominee to take place within 14 days, and for Parliament to do it within 60 days, somehow happened within 4 hours. My Lord, those are the principal reasons why we are here. And what is the immediate context? The immediate context, my lords, and why we are here is that when petitions are filed, the duty of this court under Articles 19 all the way to 25 is to ensure that it decides whether or not the violations as alleged by the petitioners has taken place. My Lord, the way in which the law, and this is express positive law, requires that to be done is by way of a judgment. By way of a judgment is the only way that the people of Kenya would be satisfied. Have these rights been violated or not? In order to ensure that that judgment, which is the express constitutional mandate, is given in circumstances that are not academic, Article 23 of the Constitution provides that conservatory orders may be given. When this matter went before your brother judges, probably a sister also, in their wisdom, they directed this matter as such enormity that we need to preserve the subject matter. That subject matter, my Lord, the preservation of it would be to ensure the relevant office remains vacant until this case, through a judgment, pronounces itself. But my Lord, why are we here and why is there a heated discussion? We are here and we are having a heated discussion because what is the clear intent of the Constitution is being circumvented, so that to ensure that the subject matter is not preserved. My Lord, this would be akin to a situation in which somebody comes and says, I am being evicted and my things are being removed. A court says, stop the eviction process up to where it has occurred. Then the respondent comes and says, no, leave those orders so that I can carry those things that it is alleged I was unlawfully taking. So that, my Lord, in the face of the fact that what conservatory orders are supposed to serve, I beseech you, and I believe the entire country would expect that there has to be preservation of the subject matter of the application. So that, my Lord, now, that being the context, it is absolutely important that we do not lose sight of the moment. It is heated, one, because there was a sitting on Saturday. Before application responses could be made, we found ourselves here. We were supposed to come here on Thursday. We are here on Tuesday. So that, my Lord, and there are a lot of matters that directions must be given. So that, my Lord, that context would be absolutely important, because when all is said and done, the critical issue before this court is a right under Article 25, the right to fair hearing and human dignity. Right to fair hearing and human dignity cannot be violated even during an emergency. My Lord, that being the background, I ask you, and we shall be asking you, because that is the context where all these things are happening, that you ensure that whether heaven falls, the High Court must stand up, if for nothing else, for the right to preserve the subject matter until this High Court pronounces itself through a judgment. Because that is express law. Having said that, my Lord, I come to the prayers. The prayers are like this, and we had already indicated. There are about 6 substantive prayers. The linchpin of these substantive prayers, my Lord, is the fact that the Deputy Chief Justice, under Article 165, does not have the power to appoint or assign, as the words used by the Constitution, members of a certain court to hear the matter. My Lord, Article 165(4) is very clear. Where the Constitution says the President and Article 149 can nominate Kindiki, there is no argument that is made that a minister or somebody else can be made. We expect that there can be no feasible argument where the Constitution has expressly said that the Chief Justice shall do something. The Chief Justice in this case did not empanel this bench. My Lord, we are urging this honorable court to make a finding that unless the Constitution is interpreted or amended to give the Chief Justice, the Deputy Chief Justice, the power to empanel a bench by express reading of the Constitution, she cannot be able to do that. Issue number 2, my lords, is that it is not for nothing that it is one of the biggest occasions that the senior most judicial officer is the one that the people of Kenya, judicial power in the first place vests in the people. Judicial power by express words of the Constitution or to do this appointment and work under Article 165 was vested on the Chief Justice. It is not by accident. It is by the express intention. So that, my Lord, on the face of it, when a state officer who is not directly mandated to do something ends up doing it under public law judicial review, it is done every day. You did not have the power under statute or the Constitution to do that. There are so many cases, starting with Madhu versus Republic. I think it was sometime in 1974, where somebody at City Council did something where the law did not allow that person to do that. So that, my Lord, all these cases we are aware of. So that, my Lord, as far as Article 165 is concerned, we submit that that is not possible. But, my Lord, this argument is developed a little bit further by the petitioner's applicants. Because the petitioner's applicants are saying that the Deputy Chief Justice, having usurped the powers of the Chief Justice, she proceeded to do 2 things. 1, to sit at night to appoint a bench, and to authorize that bench that sat on Saturday to conduct their business on Saturday. But those are irregular, because as we are saying, this is not a matter of public emergency. Of course, it was a matter of public emergency before the National Assembly and before the Senate. But because of the timelines we've given you, my lords, it is not a matter of public emergency. But having found herself in that situation, she decided to treat this matter as one of public emergency. Then, my lord, she directs come and sit on Saturday. We have set out in our applications and in our affidavit. There must be certain circumstances under our laws, the High Court Administration and Organization Act, that can justify for any bench to sit outside on Saturday and Sunday. There must be express reasons. Those express reasons, as we sit here, agreed. We still do not know them. And if we do not know them, every Kenyan who would be aggrieved by a decision made in these circumstances would have every reason to be concerned that from the word go, there was a conspiracy to commit injustice. My lord, all of you have been honorable members of the High Court. There cannot be, where there is no public emergency, for occasions to arise that for the first time, you would effectively be accused. You engaged yourself in a conspiracy to undermine the Constitution and to defeat it in a manner that would amount to treason. So that, my lord, the point that we make is that in the absence of a public emergency, what has so far happened is not only just unconstitutional, but something that would amount to violation of the Constitution and something that would amount to violations of the Penal Code as far as the issue of observing justice is concerned. My lord, for argument's sake, we proceed to make that argument. Let's assume that there was an emergency. We submit there was none, but let's assume there was one. If there was an emergency, then it was incumbent upon the Chief Justice to read, and they were in the newspaper and in the news, all these cases that honorable judges of the High Court from various stations had recommended for a bench to be appointed to hear them, to consider them, and place them for hearing on Saturday, and to fast-track that hearing. But, my lord, what is it that happened? My lord, what actually happened is that you have a situation whereby the respondents, who are basically agents of the government of Kenya and its various appendages, have gotten their applications to be satisfied and for a bench to be specially convened to sit, because from the standpoint of the petitioner, to set aside the conservatory order in order, as the petitioners contend, the violations of the Constitution may be completed. My lord, justice in this case, if it means anything, it must mean a very simple issue. The multiple violations of the Constitution that are already ingrained and embodied in the various applications, we cannot allow them to be completed, because this is what it's all about. This is what the decisions of the Chief Justice was all about, to complete the serious violations of the Kenyan Constitution. By your oath of office, your lordships are committed to stop a respondent and a government and its appendages that act in this manner. My lord, what does it amount in law for the Chief Justice to say you have about 15 or 20 cases, as I hear from my learned colleagues who have been in this matter longer than me? I'm here today for this matter, and I'm here because there is a constitution in Kenya. My lord, that being the case, there has to be satisfaction. If the Chief Justice, and she's a party in this application, cannot be able to justify why did you choose to address the grievances of the Attorney General and the government of Kenya and leave the petitioners. The first right of hearing under our Constitution, I deal with Mutunga rules every day, is that the petitioner will have their rights to be heard, to prosecute their case. That is what the Bill of Rights means. The respondent, even under Mutunga rules, will respond and answer the allegations that have been made. But, my lord, where the Deputy Chief Justice chooses to the grievances of the alleged violator, common sense has to be affected. My lord, the conscience of this court must be bothered. Such conduct in the normal sense of things. We went through the removal of judges during those days. There was just minor infractions of the right to be heard, and judges were shown the door home. But my lord, here, it is a systematic decision consciously made that would have very harmful effect for the jurisprudence of our country and for the meaning of our constitution. So that my lord, so that my learned friends can be able to speak for themselves, we are alleging that as long as the bench has been appointed by the Chief Justice, who has declined to follow the fair process for purposes of appointment of the various judges to see, there cannot be a valid appointment. Not because I and my colleagues here would have anything on a good day before any of you, your lordship. We have done very many matters. You have courageously stand up for the constitutions in various matters, but my lord, unhappily, we have to be the ones saying that it would appear to a section half of this country, if not 3/4, that you have been enlisted in service of the violations of the constitutions. My lord, that may not have happened, but that is the only way reasonable people would be able to interpret all this, particularly against the background that even the Gen Z were abducted. The substantive Chief Justice did not empanel a single bench to sit on Saturday or on Sunday. That is why this, but the context in which this matter must be viewed. My lord, there are certain authorities, my learned colleagues will go through them, but I need to mention at least two things. My lord, of course, the arguments would be made. I think there was some time back, probably in the Okiya Omtata case, my learned colleague will clarify, where the Deputy Chief Justice, the same Deputy Chief Justice, made an appointment. There was no substantive Chief Justice at that time. There was a decision that was saying this is administrative. That decision is not binding. But my lord, more importantly, now that this issue is arising directly, this court must retire, make a very reasoned decisions to settle this issue. Whether in every other case in which the constitution or statute says so and so will do this, if that so and so does not do it, without failure, the High Courts and the Court of Appeal have always held there was no jurisdiction. An order of certiorari have always issued. It shouldn't be different in this particular matter because the power belongs to the Chief Justice. Now, the second issue is a decisions, I believe, one of you was involved, and I believe it is a case of Okoichi Omtata versus JSC, and the decision in that decision was that at paragraph 29 to 38, basically it says that where there is a substantive Chief Justice who is a state officer, she does not cease to be a Chief Justice in this era of technology. And accordingly, the Chief Justice, the CJ, does not have authority under the constitutions to assign roles assigned to that office. So that, my lord, in this case, even assuming that in writing the Chief Justice had assigned this role to the deputy, and that has not been alleged, it would still not be good enough, because wherever that the good Chief Justice might be, this is something that she could have done as expected her. And the people of Kenya obviously would be interested because of the nature of this matter. Why would the Chief Justice abdicate to do her job and let her deputy to do her job in a manner that aggrieves the petitioners? That is an important question, because it is the job of the Chief Justice. There is a huge mandate that is given by the Chief Justice. Do your job with the entire authority that your office carries. So it cannot just be that it is for the Deputy Chief Justice who has usurped. It is also abdication. What would be the basis for abdication? The Chief Justice not to do their job. The other case of, just 1 minute, 1 second. The other case of, I think my learned colleague, so that it can be faster, I don't want people to knock me. My learned friend can, my learned friend can do her. Let him do his 10 minutes, then you can do his 10 minutes.
Thank you very kindly, my lords, my lady. I'll only highlight a few issues which are legal. I'll move from Article 1 of the Constitution, your lordships. That Article 1 has created organs of government. Among them is the organ of the judiciary. And it has clearly provided your lordship that the people of Kenya, in the exercise of their sovereignty, they have delegated their powers to those organs. In this case, the power under Article 165, Clause 4, is exclusively delegated to the Chief Justice. Your lordship, in administrative law, we all write that a person who enjoys delegated powers cannot further delegate those particular powers. In this case, in this circumstance, your lordship, it is not known to the petitioners under what circumstances the Chief Justice may have delegated these powers to the Deputy Chief Justice. It is our humble submission, your lordship, that the powers and the functions under Article 165, Clause 4 are not capable of being delegated. Further to that, your lordship, you seek leave under Article 159 of the Constitution, which provides that, your lordship, that judicial power is derived from the people and shall be exercised by the courts and tribunals established by this Constitution for and on behalf of the people. That article again clearly indicates that this power under Article 165, Clause 4 is not capable of being delegated. How about your lordship? In the Constitution, your lordship, I invite you to look at Article 160 or 260 of the Constitution.